Welcome to the Community Living Education Project's Sharing Possibilities for Community Connections learning event. The Community Living Education Project, also known as CLEP, is a program through Rutgers School of Public Health. CLEP is committed to providing individual guidance, mentoring, and education regarding community living resources for people with intellectual and developmental disabilities living in the state of New Jersey. The CLEP team, many who are family members themselves, can serve as a bridge for families whose loved ones may be seeking residential supports outside the family's home. Today's webinar, Future Planning to Maintain Benefits, Special Needs Trust and Guardianship, is being presented by attorney Esq.Freeman of Freeman Law Offices. To ensure the highest sound quality possible, all attendees will be muted during today's event. To interact with the host and presenter, please use your Q&A option on your screen. Topic-specific questions will be addressed throughout today's session, as long as time allows. For consideration to all of our attendees, we can encourage you to keep your questions as general as possible. At this time, I would like to welcome today's presenter, Mrs. Esq.Freeman. Hillary, welcome.
Thank you so much, Melanie. Thank you for having me. And I also want to thank the Community Living Education Project for making this available to this audience. So today I'm going to be talking about future planning to maintain benefits with respect to specifically special needs trusts and guardianships. I'll touch on very briefly on what DDD has to offer, just so you understand what we're trying to plan for as your child becomes an adult. As Melanie said, my name is Esq.Freeman from Freeman Law Offices, and I've been in this field for 16 years. I have a brother with autism. He's 49 years old. Cognitively, he's about a 2-year-old as far as we know. And I'm biased, but I think he's one of the cutest guys in the world. So that's all I have to say about that. So in my firm, we advocate for individuals with special needs across their lifespan. That includes special education and related services, guardianships, estate planning, SSI, Medicaid, and adult services. So with that, I'm going to get started. I'm having trouble. Melanie, can you share? Give me access to control. I can't change my slides.
It should be. Got it. Great.
Thanks. So the agenda for today is really a list of stuff that is going to blow your mind. I know you're extremely excited for this topic. Some things you may have heard before, but that's the agenda for today. So stay tuned. And I'll get more specific with respect to it, I guess. We're going to be talking about accepting that your child is becoming an adult. I know that that's a hard thing to accept. Please manage that today. We can just pretend for the sake of this conversation that your children are becoming adults, but you can be in denial for it as long as you want. You ensuring that your adult child is protected. That's a scary element for a lot of families. What happens as they grow up? How are we going to access support? What's life going to be like after they graduate from high school? And also what's life going to be like for when you're no longer around? I mean, generally, if you're participating in this webinar, you're guaranteed to live forever. So you have nothing to worry about. But for other people, you can tell them what to expect. So the third topic would be maximizing access to proper supports. And then lastly, how to maintain supports after you pass. And that would be where we talk about the special needs trust. Again, I encourage you, if you have any questions along the way, please feel free to type it, and Melanie will read it out to me so I can help address any questions that you have. This is a lot of information, so I just want to make sure you understand it. And sometimes asking the questions along the way will help with that. So what is it? I'm sorry. Okay. So first of all, the first topic, this is going to be quick. How is your child 18 already? I don't know. I mean, with the pandemic, everything stopped. So I don't really know how your child turned 18 already or is approaching 18. It's hard to digest. I have that issue when I have clients who I've represented when they were younger and then they're coming back and their clients are saying that they're 18. It's hard. I get it. I'm with you and I support you. If you ever want to vent about it, feel free to call. I'm happy to do it. I have a hard time saying my brother's 49 years old, but he is. And, we're getting through it slowly. So as your children become adults, you want to start thinking about what types of situations or decisions will they be making as adults. So we're generally speaking about medical decisions, financial decisions, living arrangements, relationships, and education. Medical, they really do have to understand a little bit about what their medical needs are, why doctors make certain recommendations, how they make those, why they make the recommendations, whether they should be following them, what kinds of questions that they ask. They don't have to understand all of it in detail. I know I'm certainly not a science person or a medical person, but it's helpful, obviously, if they understand the gist of what the doctor is trying to tell them. And they should also be able to express their medical needs, describe their needs. And these are just things that, topics that come up as an adult. Financial, can they make a purchase on their own? Can they manage their own finances? When I say, can they make a purchase on their own, can they use beyond more than just a credit card? Will they know how much change, if they use cash, will they know how much change to receive? With respect to, if they do use a credit card, will they understand that there's a correlation between the credit card or debit card and a bank account? Or do they just think, like a lot of people do, that the credit card is just something that they can spend money on and it never runs out of money. Living arrangements, this varies. I've had a client who was it was less severely impacted. But so we were contemplating what type of protective arrangement would be necessary. And in this particular case, she was relatively independent, except she wanted to move in with her partners, and I say partners plural because she changed partners frequently. She wanted to move in with them rather quickly, and those were the partners that took advantage of her. So her parents were concerned that she would just go off and live with somebody, and then because she was vulnerable, and they would be taking advantage of her. So living arrangements is something that in that particular case, the parents wanted to maintain control over, and they were justified in doing so based on the history of events. So they were able to, so she wasn't looking into whether the place that she lived was safe, the neighborhood was safe, the people whether they were going to be friendly to her. Not that always matters, but it's obviously helpful if you have a nice community around you. So they wanted her to live they were looking into her best interests, and they wanted to look to make sure she was safe. So that was something that they wanted to maintain control over. She could make other decisions, but with respect to living arrangements, they needed to take care of that. Relationships, similar to the example that I just used, it's important to learn when a relationship is legitimate. It's whether you're in the type of relationship that you want to be in, whether you recognize when you're being taken advantage of, if you're being taken advantage of, or if the person is a good partner for you. These are just factors that you're thinking about as adults. And so when we're looking at protective arrangements, we're looking at, can your child make these decisions, and it would be in their best interest, or would it put them in harm's way? And then lastly, education. This would apply 18 and older. Generally speaking, what type of education do they want? Where do they want to go to school? Do they want to go to school? Do they want to continue learning if they're going to go into a certain specialty, or do they feel like they have enough education to advance in whatever industry that they would be interested in? So these are situations, like I said, where a protective arrangement may be necessary, and that it won't be a guarantee, but these are just things to think about. Okay. So there are different types of protective arrangements when we're talking about adults with special needs. There's the power of attorney, conservatorship, and guardianship. This goes from least restrictive to most restrictive. The power of attorney is there's no legal proceeding required. You don't have to go to court. An attorney can draft up a document for you, or you can actually, the individual can draft up their own document, provided that the requisite amount of witnesses are present when the documents are signed. But you don't, the benefit of the power of attorney is that no legal proceeding is required. The individual is, in this particular situation, is authorizing somebody else to make decisions on their behalf when they're not able to make it for themselves. But in order for this power of attorney to be legitimate, they have to understand what they're doing. They have to the individual has to understand that they're giving the ability for, they're giving somebody else the ability to advocate and make decisions on their behalf. If they don't understand it, the power of attorney is technically unenforceable, and it's not legitimate. So that's just, again, when you're determining whether a protective arrangement is necessary and what type, that's something to consider. When I'm drafting a power of attorney for a client, for a child who's now an adult, I will always meet with them to make sure that they understand what decisions they're authorizing somebody else to make. Sometimes the individuals don't necessarily want their parents to still be involved in their medical decisions and talking to doctors, or because maybe they want some privacy and they don't want their parent to know something. That's something that they have to be aware that they might be giving up, depending on how the power of attorney is written. So again, this is just something to think about. If you think that this would be appropriate to kind of guide your child, but not necessarily take their rights away from them to make these decisions, a power of attorney could be appropriate. Again, they have to understand what they're doing. Another key element of a power of attorney that I don't love is that it's orally revocable. So unlike guardianship and conservatorship, power of attorney, if they are authorizing you to make decisions on their behalf and they don't like the decisions that you're making, they can say, forget it. I don't give you that right anymore. I'm taking it back. And that's enforceable if you're around somebody who knows the law. So that is often an issue if an individual is maybe less severely impacted or who has a mental illness that is under control under certain medication, when they are no longer on their medication, then their judgment is questionable. This becomes, and the fact that a power of attorney is orally revocable can become an issue. So that's, again, that's just something that if they're generally cooperative and they go along with your decisions, and they understand that you have their best interest in mind, then this is fine. This could be fine. If they're pretty oppositional, it might not be acceptable or might not be sufficient to make sure their interests are being protected. Any questions so far? Okay.
We have 2 questions, but not specific to this part yet.
Okay. So with respect to guardianship and conservatorship, we don't see very often for individuals with special needs. We see it more for as parents get older. But conservatorship is, generally speaking, what the law says is that it just covers property. It doesn't cover medical needs. So essentially what you're doing is the individual says, I want my parent or sibling to still be able to make decisions with me over my finances, or help manage my finances with me. It's a voluntary process. So the individual has to consent to somebody else serving as conservator with them, or I should say over their assets. But the law says that the conservatorship does not apply to medical needs. I'm not going to say it's never happened where a judge didn't order conservatorship over medical needs, but under the law, they're not supposed to. So take it for what it's worth. I wouldn't advise a client to get conservatorship if they feel that they need to assist with respect to medical needs as well, just because that's not going to necessarily accomplish their goal. But so if the individual is says it's fine, wonderful. If they want to revoke that, then the parent will have to make a decision as to whether they want to proceed with guardianship, which it doesn't have to, where the individual does not have to consent, or whether they feel that their child or sibling can manage their finances on their own. It is a court process. It is more permanent than the power of attorney. But the benefit is you're not taking their individual's rights away. You are helping them along the process. Guardianship, though, is what we're mainly going to be focusing on today. This is what I would say is probably the most restrictive out of the three options of power of attorney, conservatorship, and guardianship. Guardianship is essentially, it applies when the child is turning 18. You can apply, and they can't make decisions for themselves. You now can apply to the court to become their guardian. And essentially what that's doing is giving you the rights that you would have if they were under the age of 18. So if you go for full guardianship, you have the right to make all medical decisions on their behalf, all financial decisions. You can decide where they live, decide what they wear to the extent that you care. You can advocate for their education. You can talk to people on their behalf. And that is what we call a full or plenary guardianship. Okay. So you're still, even if you do become the guardian, you're still required to include the individual on decisions and take their wishes and desires to heart when making decisions for them. And you're also required to give them as much independence as appropriate. That would be plenary guardianship. You have full control as though the child was under the age of 18. There's another form of guardianship called what we like to call limited guardianship. And a limited guardianship is what I call guardianship with carve-outs. It's a plenary, it's telling the court, my child is 18 or older, as in some cases. Even though they're an adult, they can't make all decisions on their own. I need to help them make those decisions to protect their best interests because of their disability. But they can make decisions in certain areas. So maybe they can decide where they want to live. In this example that I gave when we started this presentation, we arranged for the limited guardianship, which was a really good happy medium for all parties. What we did for the living arrangements was we said in the guardianship order that the parents had to give their daughter 3 options of where they wanted to live, of where they believed were appropriate for her to live, and she could pick out of those 3 options. So it was they were happy because they knew that she would be picking a safe place, and she was happy because she felt like she had control over where she lived. So that was a good happy medium that we came up with for the limited guardianship. Other situations where a limited guardianship might be appropriate is that maybe they can manage their finances, but they can't make medical decisions on their own, or vice versa. Maybe they can make medical and financial decisions, but they're is socially and in terms of whether they should be able to marry or be involved in a relationship, maybe that's a challenge. So I call it a guardianship with carve-outs because when a limited guardianship is appropriate, we're going through detail by detail, which we would otherwise do anyway, and to figure out what can the individual do on their own. Where is that happy medium to the extent that there is one? Where would the parents feel comfortable with the individual making decisions on their own? Something to think about when you're making these decisions or trying to determine what would be appropriate. If you were to leave your child, first of all, would you leave your child home for 2 weeks without give any guidance whatsoever? Okay, you can say a week or 2 weeks, I don't care. But without any guidance, that means no checking in, no prompts, Okay, no instructions on how to cook food, how to get food, who to call. There are literally no instructions whatsoever. And how would they handle that? And I think that's a good starting point for determining whether a guardianship is appropriate, whether something less restrictive might be appropriate. That's the starting point. And then we go into the more detail, which we'll get into in a minute, on other factors that you would consider in determining whether guardianship is appropriate. So I did mention this, but once you are the guardian, I mentioned it from another angle of decisions that you have to make as an adult. But when you are the guardian, you do have the right, assuming that you go for full guardianship, you do have the right to make the healthcare decisions, protect their finances to the extent it's necessary, advocate for their educational needs, and help them live in a safe environment wherever that might be. So you can advocate for them and also help them identify a safe living arrangement if it's not going to be with you at home. So those are some other guardianship rights that you'd be entitled to. A lot of the laws are getting a little, I should say the courts are getting a little bit more strict with respect to guardianship over the property. You can go for full guardianship, but if the individual doesn't have any property, and this is outside of a special needs trust, like if they don't have any money directly in their name, then judges might say, well, we're not going to grant guardianship over the property right now. Or they might say, you can come back and get it. Or they might say that it's not necessarily, we'll give it to you, but a bond is required if there are some limited finances. So we're not quick to recommend that you get guardianship over the property right now, under all circumstances. Sometimes it's not necessary. So, and it's just an extra headache for you. So we might advise you differently depending on the situation. So any questions about the guardianship or anything that I discussed so far?
Hillary, you do have a couple of questions. How would you go about changing the type of guardianship? So for example, if someone has partial guardianship and wants to apply for full guardianship or vice versa?
Good question. You have to go back to court and seek a modification of the guardianship order. You would need to go through the guardianship process to justify why you're going to need a change. And I'll get through it in a minute, but you'll need the doctor certifications to support what you're asking for. And a court-appointed attorney will get involved to make sure to advocate for your child's best interests. But you'll have to go back to court to make that happen.
Okay. And I'm not sure if you're going to address this moving forward. So if so, we can wait. But someone's asking, what do you do when you have a 35-year-old daughter with no one in the family that is willing to be named as a guardian if something should happen to this parent in the future?
That's a hard situation, but a good question. If nobody is willing to be guardian, I'd wonder why. If they have no relationship whatsoever, I understand it, and you might be concerned about that person serving as the guardian. But sometimes I run into that because the other family members feel as though they can't handle the responsibility. And under those circumstances, there are some things I just like to point out. If you are the guardian, that doesn't mean the person has to live with you. My brother's been in a group home since he's 21, and my sister and I are co-guardians. He does not live with us. As much as I love him, he couldn't live with us. We all work. It's just, and he has a lot of medical needs that we wouldn't be able to attend to as much as we would love to. So we are available should the need arise. If he has to go to the hospital or make decisions or have meetings, we're available, but he doesn't have to live with us. So that sometimes puts people at ease. So I would go through try to find out first why nobody's willing to. But if at the end of the day they're justified and simply that's the case, then I would look for a friend. or maybe a nonprofit agency would serve as the guardian, such as Plan of New Jersey. I believe the ARC serves in that capacity too. So there are Plan of New Jersey. I love they charge a minimal fee, and they will check in and advocate for your child's best interests and help make decisions when you're not around. So that's a long answer, but I would go through that analysis before making any decisions.
Right. So we have someone who is the age of 75, their child is 53, and they want to know what the process is for naming a co-guardian.
So I'll get through that in a few minutes because that's 3B of my outline and then in my head. So I'll get to that in a few minutes in order for that to make sense.
Okay. Again, similar question: should siblings be added as a guardian if only the parent is listed as a guardian? I'm assuming that you'll get to that also.
I will. That part I can answer quickly now, and I'll get touched upon it more a little bit later. We used to say that the sibling does not, you don't need to appoint the sibling as a co-guardian right now, depending on your age and what you feel comfortable with. The reason for that is that if they're co-guardians, they have the right to make decisions as equally as you do. And sometimes some parents have a hard time with their child having given the same rights as them to make decisions over one of their other children. So if that's the case, then I probably would hold off, and then you can appoint a backup guardian in your will, which we will get into a little bit later. But if you don't get along necessarily, then, or you're concerned about balance of power, for lack of a better term, then yeah, I would hold off. But if you think that having them get involved now would help because it'll help smooth the transition, then yeah, it definitely does not hurt to do that. That's what we did in our family because just frankly, my parents were getting older and they're tired and they don't necessarily want to make all the decisions on their own because the decisions that they make now are going to impact us. So my sister and I stepped up and we are the co-guardians. My parents still are, they're still the guardians as well. 4 people all at once can be fun sometimes, but we ultimately are able to make decisions for his best interest and we come to an agreement. So you're gonna have to do what's right for your family. I'm not gonna give you an absolute answer on that, but because it is personal, but if you find that you're aging or you're getting tired and you think that it might be beneficial to get more assistance, or the alternative, maybe it'll get the person, your other children more involved, then yeah, I think that it's okay to do that now.
Great. So we have actually a lot of questions coming in. Can we get to 2 more right now and then we'll hold?
Sure, absolutely.
So someone is asking, what is the benefit of doing a partial guardianship opposed to a full guardianship? Couldn't you just do supported decision-making regardless of either? And does partial cost less than full guardianship? And before you answer, if I could, actually CLEP is hosting another webinar in I believe it's January, possibly February of 2022 in regards to supported decision-making. Understanding, like Hillary just shared, this is a really personal decision for each family to make for the person that they're specifically supporting. So we're just really making sure that we're sharing all options at this point, but supported decision-making will be presented on in the beginning of 2022. But Hillary, if you have any comment to that?
First of all, the easiest of the answers is that limited guardianship and full guardianship are the same price. So that's in my office. I can't speak for other people or other firms, but the advantage of it is a hard question to ask because it depends on the individual and the individual circumstances. I think that sometimes some parents have a hard time deciding whether guardianship is appropriate. They know that it's probably better to have it in place than to not have it in place, but they also are uncomfortable taking all of their children's rights away, which is kind of what you're doing. That's when we go through detail by detail to determine whether that's appropriate, whether full guardianship is appropriate. I find that it's easier to go less restrictive when the individual lives with you. When they are, and I'm saying this isn't legal experience, this is more practical experience. If and when they move out, having guardianship or more, having guardianship does give you more control over the situation. So if my brother who's in a group home, they have to consult with us on all decisions. Granted, my brother is very severely impacted, but they have to consult with us on all decisions. They have to call me if he has a seizure, if he gets injured, because he falls a lot. If he has behaviors, if they want to adjust medication or take him to a certain doctor, they have to call us and get our permission before they can do that. If you don't have guardianship and they're not living with you, then if you're challenging another decision, it makes it more complicated. It makes it more difficult for you to challenge. You might get more pushback. So those are more of the advantages when the individual doesn't live with you.
Perfect. So we have quite a few questions waiting to be answered. We're going to hold the rest. I will say else is asking what happens to an adult with a disability when the only guardian passes. I'm assuming you may touch base on that moving forward also.
Yeah, so you can appoint a backup guardian, such as Plan of New Jersey or a nonprofit agency, if you don't have a friend or family member that's willing or that can step up. If you don't appoint anybody, then DDD will serve as the guardian and appoint somebody.
Perfect. And everyone, I know all the questions are important, actually really interesting questions coming in. So we are going to hold some of these for the end. And Hillary, if you have time, we can even extend the session for a few minutes if convenient for you.
Yep, I built that in. And also feel free to email me at hillary@freemanlawoffices.com with any questions as well. Okay, so questions to ask when determining whether guardianship is appropriate. Some of the first questions that I ask are, what are the child's academic abilities, who is now an adult? Can they add and subtract single step problems, multiple step problems? Can they write? If they can write, is it legible? Can they read? Is it simple, one word? Is it just sight words, or can they read paragraphs? Do they understand what they're reading? And if they can, at what level? We'll also go into whether they can communicate. So do they have expressive language? Do they have receptive language? Do they take turns, or do they just talk about what they want to talk about, kind of like what I'm doing now? Can they be taken advantage of? Are they vulnerable? If somebody offers them candy, will they go for it? Or in my case, my brother is obsessed with his iPad and Sesame Street on his iPad. So if anyone has an iPad with Elmo on it, he's gone. So to what extent they will listen to other people telling them what to do. And is it a wise move for them to do that? Can they advocate for their own needs? Can they describe their disability? Do they understand what their needs are? And do they know how to ask for help and where to get the help when appropriate? Can they manage their own money? I mentioned this before. Can they make a purchase on their own? Do they get change? Do they count the change? Do they understand the association between a credit card and a bank account? And not everybody understands stocks and bonds. It's not a criteria in determining guardianship, but the basics of managing money is something that you would want to consider. Safety awareness, will they walk off with strangers? Will they walk across the street by themselves? If so, will they look both ways? My favorite goal in an IEP is that the student will learn to cross the street 80% and mastery is considered 80% of the time. I don't ever understand that, because they really should be able to cross the street independently 100% of the time. If it's only 80%, then arguably there can be some issues. So can they do that? Can they drive a car? Can they understand that, like, when to turn, if a stove is on, that they shouldn't touch it? Or will they remember to turn off the stove if they're using it, or turn off the oven? What will they do in the case of a fire? These are all just factors that you want to consider. Nothing is determinative of whether guardianship is appropriate. These are just factors in determining whether guardianship might be appropriate. Okay, nothing is determinative. Will the hygiene, do they wear the same clothes all of the time? Will they wash their clothes if they do wear it all the time, or when they're dirty? Will they shower? Do they shave? These are, again, just, do they brush their teeth? Do they understand that they need to brush their teeth in order to avoid cavities and to protect their teeth? And by doing so, it will avoid pain in their mouth. Will they wash their hands and get rid of germs? Do they understand to the extent when COVID, obviously the pandemic is still around, is still here, but do they understand the need to wear a mask and the benefits to wearing a mask when under certain circumstances, or do they not pay attention to that at all? So again, these are just factors to consider. Medical needs, I mentioned this before, but I'll mention it again. Do they understand why they're taking medication, what the benefits are? Do they understand when to take medication and how much they should take? Or do you have to put it out in a pill box for them? Do you have to give instructions? Do they understand when to talk to a doctor, what doctor to go to, and maybe if a doctor recommends a certain procedure, do they understand why the procedure is being recommended, and should they consent to it? So that's these, again, just factors to consider. And I mentioned communication skills already. So do they walk up to somebody and know that and give background information or introduce themselves, or do they just walk up to them and pretend like they've known them all along? If it is a stranger, if they can communicate, can other people understand what they're saying, or do they just do you have to really know the person in order to understand what they're saying? I talk about my brother a lot. I'm happy to, but just another example for him, he repeats Sesame Street skits all day long. So we study Sesame Street skits, and I can tell you the skit for any single Sesame Street skit you want. But if you don't know the Sesame Street skit, he'll just go to somebody else until somebody can interact with him. That is something that we find adorable, but somebody else might not be able to communicate with him. It's not going to get him to his ultimate goal. So that's, again, things to think about. The guardianship process, it has changed a little bit over the years, specifically this year. Not necessarily related to the pandemic, but it's a little bit more complicated than it has been in the past. You can start the process a few months before your child turns 18. I would recommend about 3 months before they turn 18 if you're going through an attorney. You can do it by yourself. You might want to start a little bit sooner than that, just because there are lots of forms to fill out. But if you're doing it yourself and since you're not familiar with the process, most likely you might want to start earlier. But you can't file the paperwork until they turn 18. So a lot of people ask, well, what happens between the filing of the paperwork and when you actually get the court order, which is usually about 3 months. If there's an emergent situation, then we can ask for temporary guardianship during that time. And we'll do that in the initial complaint. If there's not an emergent situation, then they'll tell you to wait until there's an emergent situation. Otherwise, you would go through the entire process. So what will happen is you file a complaint for the guardianship, and in that complaint, you're setting forth all of the reasons that you believe that your child is in need of a guardian. So you talk about all of the factors that I mentioned before: academics, decision making, medical needs, managing their money, if they have behaviors, what those behaviors are. You go through all of the reasons why your child needs a guardian. You also will need 2 doctor certifications to support the need. They have to be seen with the paperwork has to be filed within 30 days of them seeing the first doctor. So that's just something to consider when making your doctor's appointments. We'll guide you through the process if you go through our office. If not, I would still recommend that you just look at the timeline. It can be extended, but you have to file some additional forms to extend that deadline. So generally speaking, it's a good idea to draft the complaint and to have both doctors see your child within 30 days of each other. And then filing the guardianship application. You can see 2 doctors in the same office. You don't have to, but you can. You can do a psychologist and a medical professional. If your child is already DDD eligible, you really only need 1 doctor. But if it's easy enough, I would get 2 just to seal the deal and you don't have any concerns later on. You'll need to provide the IEP. If somebody other, this is a new part of the guardianship process. If somebody other than the parent is applying, they might have to be subject to a background check. They might have to get fingerprints. And if there are any issues in their background, then that will be investigated further. That is definitely a new development this year. That's not related to the pandemic. It's just a coincidence that it happened at the same time. So that is something to consider when appointing somebody else. Their background will be looked into. If they have a problem in their background, then it'll be investigated. They just have to be okay with that. And then there's the $200 filing fee. So you file all of these documents with the court will then appoint an attorney to represent your child. If your child is more severely impacted, it generally is somewhat of a formality. The attorney will meet with you and your child, sometimes remotely, sometimes in person because of the pandemic. They'll make sure that everything in the guardianship complaint is true. They'll find out if your child is contesting it, and if so, that position will be represented to the court. And if they agree with the guardianship, then they'll write a report indicating that. If they don't agree with the guardianship, then they will also write a report opposing that. They'll give it to the court, and then if it's contested, their court appearance will be required. If it's not contested, then it will likely just be decided on the papers, which means a court appearance is not required. Then you'll get the order, and then you'll have to just certify that there's also a video, by the way, that you watch about the guardianship process and understanding your rights. And then you submit this to the court will issue an order, and then you'll be given short certificates to prove that you're the guardian when you actually need to present it. Any questions about that process?
So we have quite a few questions. If you're comfortable, Hillary, I'm going to let you get through your information, if that's okay. That way, anyone that may have to sign off, at least they're getting the info. And then at the end, we can do Q&A. Does that work?
Okay. Yep, that's perfect.
Great, thanks.
Perfect, thank you. So, okay, so with respect to the adult services, you've now applied for guardianship, or maybe guardianship wasn't appropriate, and maybe you went through conservatorship or power of attorney, or maybe you're going through supportive decision making. Either way, your child is now becoming an adult and they're aging out of the school district. So what happens then? If your child has a developmental disability that's accrued before the age of 22, they would likely be eligible for services from the Division of Developmental Disabilities, which is DDD. Okay, and what does DDD provide? They provide job coaching. Medicaid provides healthcare. DDD provides sometimes support for health medical needs, such as a behavioral therapist or somebody who works in a group home. But they don't actually provide doctors. They will take the individual to the doctor. They provide residential options. So they provide group homes, although they're not called that anymore. They're called residential homes. They provide supervised apartments. They provide in-home support. So sending people to your home to provide behavioral support or job coaching or activities during the day, help them with respite or take them out for activities during the day. This list is not exhaustive. These are just some examples. But they can also give you money to develop your own program. So these are different things that you can get when your child becomes an adult to help them be as independent as possible. They provide behavioral supports to the extent necessary. They provide speech and language therapy, which is relatively new. They provide day support. So it could be anything from a sheltered workshop where they go to the same place every day and they do jobs within that environment. Sometimes people like that because it's the same routine and they feel comfortable in that environment. Other individuals go out and work in different offices or work in the whatever industry that they're interested in, and DDD might provide a job coach to help them if to the extent necessary. When the pandemic, prior to the pandemic, we had somebody in our office who was awesome. He came in every day, once a week, for I think 6 years, to help with various tasks in our office. And as much as I tried to promote him, he didn't want to be promoted. But he was fantastic, and he had a job coach who can help. And I just loved having him there. So people, they can work in law firms, they can work wherever they want, wherever they feel that they're qualified or what the jobs they're interested in. DDD will help provide support so they can work in the environment that they're interested in. So this is a little bit out of order, but so when we're talking about DDD, we're talking about advocating for these services, and we're talking about when the child turns 18, all of these different factors to think about to help your child be as independent as possible. So you've made these decisions, and now as you get older, you might want to appoint a backup guardian, or through either your last will and testament, or you can do it through you can have them apply for the guardianship process now to make it easier, so they can maybe learn how you're making decisions and advocating, and then they can pick up where you left off when appropriate. I've seen, so when we're doing a will, you have to appoint a backup guardian, and you also have to appoint a trustee. And when people sometimes want to appoint two guardians, so there's a system of checks and balances, or a different person for guardianship and guardian and trustee, because the guardian is there to advocate for the individual's best interests, but the trustee is there to manage the money. Sometimes they want two different people for that system of checks and balances. My perspective on that is pick people you trust. If you don't trust them, then don't pick them and appoint them in those roles. So you can, legally, can you appoint multiple people? Yes. The practical side of it, though, is that if you appoint multiple people in different roles, there's increased chance of conflict. And when you're asking somebody else to take care of your child or advocate for their needs, I'd like to try to make it as easy as possible for them to do so. So if you appoint the same person as maybe the guardian and the trustee, then you're asking them to advocate for the individual's best interests, but then you're giving them the money to do it. Rather than if you appoint two different people, the guardian has to ask somebody else for money to advocate for your child's best interests. Things to think about. Again, this is based on your personal situation, but these are just factors to think about when determining who you're going to pick as successor guardian. If you don't have anybody, I mentioned before, you can pick a friend, or you can Plan of New Jersey or the ARC. They could serve as backup guardian, and they can also serve as trustee of the Special Needs Trust. So I think I answered the questions around that that you already asked about that. The letter of intent are wishes that you have for your child. So there are two different things that you can do with the letter of intent. It's kept with your will, so you don't have to change your will every time. You can change the letter of intent as time goes on, and you can address in there your child's doctors, their allergies, things that you've tried that haven't worked, things that they really like, to help the next person take over as smoothly as possible, make that transition easy. You can also talk about your wishes for them. If you never want to see them go into another state, so you can put in the letter of intent that it's your desire for your child to stay in the state of New Jersey, if that's where you live right now. So these are just, your wishes can change. You don't have to modify your will every time, but your will can reference the letter of intent, and just keep it together so they know what you're talking about. Other pieces, you want to think about funding the special needs trust to ensure that money is available for your adult child with special needs. We'll get into the special needs trust in a few minutes, but you want to think about how you are going to fund the special needs trust. Your will generally directs money to go into the special needs trust. They can be the same document. I like them to be separate in case you need to make any modifications, or if they're in the same document. So your special needs trust is in your will, then there's no way of funding the special needs trust until you die. If they're separate documents, you can start funding the special needs trust if you want to, or if you need to, before you die. And it just helps. Again, it's just a little bit smoother. So you want to think about how you're going to fund the special needs trust. Many people fund it with life insurance. If you can't get life insurance because it's too expensive, you might want to think about, there are cheaper options like a second to die policy, where the second of you that passes away will fund the special needs trust. It's cheaper because neither one of you take advantage of it as parents, but there will be money available for your child with special needs. And the benefit of doing something like that is that you don't have to worry about your retirement. You can enjoy your retirement while also knowing that this other money is available for your child with special needs. There are other ways of managing your estate, but that's just an example of how you could fund a special needs trust, even if you don't have any money right now. Life insurance is a great vehicle to do that. So I mentioned before, the child does not have to live with the successor guardian. Sometimes siblings live out of state. That's okay. You just want to make sure that they can be available when necessary. I particularly recommend that any successor guardian be at least 25. They can be younger. They can start at 18, but there are lots of decisions that are being made between 18 and 25. There's a lot of maturity that happens there. So I generally recommend that the successor guardian not serve until they turn 25. Again, it's a personal preference. Some children mature much faster, but that's just something to think about. And then, so the question would be, we talked about wills, we talked about somewhat the special needs trust, but why are we doing all of this? In order to qualify for the adult services that I mentioned before, they have to be eligible for Medicaid. Medicaid is the primary funding source for adult services. So it's health insurance, but it's also the primary funding source for adult services. So if they're not eligible for Medicaid, they will not be eligible for any of the adult services. And you might be having to figure out a way of funding their adult lifestyle in a different fashion. So in order to be eligible for Medicaid, there are income restrictions, there are resource caps that I'll go into, but you want to think about how you don't want to give them money because it'll jeopardize their government benefits. So instead, the will direct money to go into a special needs trust. And by doing that, the special needs trust will protect that money so they can qualify for government benefits and also have the money on the side to supplement what the government provides. So when your child turns 18, we mentioned guardianship at length, but you're also thinking that your child would likely be eligible for SSI and Medicaid. So you're doing the guardianship application, you're knocking that out to the extent that it's necessary. And then also you can fill out an application for supplemental security income, which are monthly checks that go to you for food, shelter, and clothing for your child. And then if your child is eligible for Medicaid, they would then qualify for health insurance and for adult services. The health insurance is, I would call it an emergency plan. It's not a terrific plan. It will cover the basics. What we recommend, if you can do this, is supplementing the Medicaid with the private health insurance policy. Either keep them as a dependent on your policy. Many plans can do that if your child is still dependent on you, or look into an individual policy for them. It allows for more variety of medical resources, because not a lot of doctors or medical professionals accept Medicaid. So having that extra private health insurance policy will make that available to them. But again, SSI are monthly checks that go to you for food, shelter, and clothing. Medicaid is health insurance, but more importantly, it's the primary funding source for adult services. So in order to, and by the way, these slides are going to be available to you. Melanie has them, so she can send them out as requested. But this is the different criteria for eligibility. For SSI, they must be 65 or they must be either 65 years or older, blind or disabled. They should revise it to say person with disability, but they haven't done that yet. So they have to have an income of less than $825.25 in gross monthly income, or $1,216.35 for a couple. And then resources, generally speaking, they have to have less than $2,000 in their name if they're single, or $3,000 if they're a couple. So that's the SSI eligibility. Medicaid, if they're, I mentioned before, if they're eligible for SSI, they're automatically eligible for Medicaid. If they're not eligible for SSI, there are other ways of becoming eligible for Medicaid. I'm not going to go into it in detail, but there are other ways of making them eligible for Medicaid. But so the general rules are they have to have less than $825 monthly income and have less than $2,000 in resources. And if that happens, they should be eligible for both. So a question that I often get is, and we're almost done, don't worry, but what I often get is, can you charge rent? The answer is you should be charging rent. Okay. If your child is over the age of 18 and they're living with you, you should be charging rent. And I put this chart in for, so you can understand the difference in what happens. If you don't charge rent, there's a certain amount that will be deducted from their SSI because that will be considered income to them. Okay, so they would otherwise be eligible if they're living alone or with others, they'd be eligible for SSI anywhere between, and this is not the set amount, but between $500 and $800, or $600 and $800, or $825. So they could be eligible for that amount of money. If you go down and you see person living with somebody else's household and receiving support and maintenance, that's the rent, their amount of SSI will go down to $573.65. So if you charge rent, then they will get more in SSI. If you don't charge rent, it will be reduced. Okay, so what I recommend is that you charge, maybe depending on your mortgage, you charge maybe $200 to $300 in rent. You can set it up on when the SSI checks come in, you can have it on automatic withdrawal and then go into your bank account, and you'll likely be using it for their benefit anyway. But it's a way of maximizing the amount of SSI that they get. Okay, so that's just an example. So I would highly encourage you, if you're not charging rent, to do that. Okay. And so lastly, I just want to talk about the vehicles to ensure that they continue to be eligible for SSI and Medicaid. I mentioned your will. Your will directs your assets and your estate to go to whoever you want it to go to. To the extent that you want to leave money to a special needs child, then you can fund a special needs trust. That again, the trust is a vehicle to hold the money, so to preserve their eligibility for government benefits. There are different types of trusts. I would focus more on the third-party supplemental trust for the sake of this conversation, but these are the highlights and the differences. The third-party trust is where you're funding a special needs trust with somebody else's money. So it's a parent is leaving money to the child with special needs, and instead of giving it to the child, they put it into a special needs trust for their benefit. And it's uncles, grandparents. The point is, it's from somebody else other than the individual with special needs. If you set up this special needs trust, your will can direct money to go in there. Your life insurance can go into that as well. You can put a house in there, but I don't recommend it. So that is something that that's there. If you set this type of trust up, there's no Medicaid payback provision. So if something happens to your child and there's money left in the trust, it can go to whoever you want to leave it to. Versus a self-settled, or what's also known as a first party special needs trust. That's when you're moving money, your child's individual money, own money, into a special needs trust so they can qualify for government benefits. So the benefit is they have a lot of money, they need Medicaid benefits. So you're asking the court essentially to move it into a trust so they can qualify for government benefits. And then they would. So there's a benefit to that. The downside, though, is when they pass away, if there's any money left over, Medicaid will be able to attach a lien to the assets in the trust. And before that money goes to anyone else, you have to look to pay back Medicaid for the services they've been providing all along. So I don't know about you, but I give enough money to the government. I don't want to give them any more. So I usually recommend, to the extent that you can have control over this, funding a third party trust rather than a self-settled special needs trust. Again, sometimes you can't avoid it, but those are the differences between the two. And lastly, an ABLE account. There's lots of benefits to an ABLE account. It's a tax-free savings account. You don't need an attorney to set it up. You can invest up to $15,000 tax-free, up to $100,000 total. There are lots of benefits to the ABLE account. The downside is that if you're comparing an ABLE account to a first party special needs trust, there are fewer investment options than a special needs trust. But similar, like the first party trust, there's a Medicaid payback provision. So in the event there's any money left in an ABLE account when your child passes away, it may go back to the government to pay back for services they were qualifying for all along. So sometimes if you're setting up an ABLE account, I think sometimes it's wonderful. Just watch how much money you put in there, because again, if something happens to your child, what's ever left in there could go back to the government. So again, just pay attention to it. All great vehicles to preserve your child's government benefits. If you have a special needs trust, you would appoint a trustee to manage the money in the trust. I mentioned before, either guardians to advocate for your child's best interests. When you have a special needs trust, you have a trustee to manage the money in the trust. Okay. And in our case, my sister and I are both the guardians and the trustees of the money. So guardians of my brother and trustees of the funds that are in the trust. And when we pass away, there are backups that are appointed. So that's essentially a really quick overview of how to maximize the amount of services that your child gets. You want to watch the amount of money that goes. You want the ability to advocate when necessary. You also want to make sure that they don't have. You want to watch the amount of resources that are in their name, so to ensure that they continue to qualify for adult services. So we talked about guardianships. We talked about DDD. We talked about SSI and Medicaid. And special needs trusts. So with that, any questions?
So we have a lot of questions. Can you talk a little bit about someone obtaining guardianship, and would that obstruct someone's right to become a registered voter?
You have to be able to sign your name in order to vote. So it does not obstruct their right to vote. It could obstruct their right to drive, but it wouldn't, but not voting.
Perfect. So we have a parent asking a question. Mom and dad are currently separated. And the father just announced that he's going for full guardianship without consulting the other parent. Can you talk a little bit about, is there an appeal process, or would both parents have to be in agreement for this?
So you don't have to be in agreement, but it's more challenging if you're not. So you absolutely have the right to oppose it. So if the father goes for full guardianship, they would have to notify you. They would serve you with the papers. And in that, it should give you instructions on how to contest that. And then sometimes the court will, the judge would try to mediate. But ultimately, it's pretty hard to get sole guardianship. The judges, the guardian, the surrogates, they like to continue the arrangement that happened before that was in place before the child turned 18. So unless you did something, or if like your parental rights were terminated, or you did something that was very harmful, or it was maybe negligent, it's unlikely that a court would order it if you oppose it.
Perfect. So we have a family member sharing that their loved one is going to need some extensive dental work done and will require anesthesia. The individual is going to have to go in the hospital to have this work done, and the hospital is requiring either power of attorney or guardianship. Are there any options just to have paperwork for medical procedures, and how, what's that process and cost? The family member.
So you can do a power of attorney for just medical procedures if the individual understands what they're doing and they're giving you the right to make those decisions. Sometimes the hospital will have a form that you can just fill out under those circumstances, so you don't even need to hire an attorney to do that. The guardianship process, I don't recommend that you go for, well, if you're going to need to be guardian for ongoing medical decisions, then you might want to go through that process. But if it's just for a limited one procedure, then I probably wouldn't go through that for just that procedure. And so I'm happy to go into more detail, but that's the most general amount of information I can give right now.
Perfect. Would you agree that some hospitals have a patient advocate that maybe
Yes,
we can reach
absolutely.
out to?
Yeah.
Perfect. So might be a good contact for them. Let's see. We have someone saying that their wife and themselves are guardian for their wife's brother who has a disability. The judge imposed a bond over a special needs trust established by the mother-in-law's will, over which they are already trustee. The attorney did not require the bond, but the judge did it anyway. How can they get the bond removed because it's wasting money?
I'd have to have a separate conversation with you about that.
Perfect. Yeah, I think that, right, a lot of times there are questions that you have to ask.
Yeah, I'm sorry.
Right?
Private.
No.
That's a little bit more challenging. I'd have more questions to ask.
Not a problem. Let's see. Is it best to wait for the guardian to pass to apply for guardianship over a sibling, or do it before the guardian passes?
Hey, that's a personal decision. I mean, obviously, because to the extent that if you know that the guardian is about to pass or is getting close, then I would probably, you can appoint a backup guardian through your power of attorney for when you're alive. So you have somebody there to help make decisions if you're unable to make them. I mean, there are different options. So I think it's easier if you do it now when everybody's alive, so they can have more involvement in the decisions. But if there's going to be some argument or if there's disagreement as to the best approach, then I would probably wait until the guardian is no longer around, because this way it minimizes the conflict. They have control now, and then you would have the successor guardian would have control later.
Right. And if a family member gives a gift, something like a coat or something tangible, will that affect any of the individual's funding?
It's very unlikely. It depends on what it is, but a coat is unlikely to affect the individual's funding. A house, something of more significant value could, but a coat probably not.
Okay. Regarding letter of intent, is a letter of intent legally binding? And if not, can it be made legally binding?
Yeah, it is.
Oh, I'm sorry.
Go ahead.
And also, is there an outline that you would suggest for the content of a letter of intent?
No, but I can certainly create one. That would be a fun thing to do in my free time. I will create one, that's easy to do. It is binding because your will directs. If your will directs you to honor the wishes in the letter of intent, it's nobody's going. I don't. It's going to be difficult to challenge, but they should be honoring it. There's the legal and practical side. The law says honor the letter of intent, but it will definitely be difficult to challenge if you're no longer around to say that they're not following it. So that's the caveat there.
If someone moves to a different state, do they need to redo their will and special needs trust?
So they might not need to redo the special needs trust, but they should consult with an estate planning attorney to make sure that they're complying with the right, they're managing their estate in the best way for that particular state. With taxes and things like that, they do vary from state to state. Guardianship does need to be transferred, though. If the child moves to a different state, it does need to be transferred.
And do you have to file a tax form for a third-party trust?
Once it's funded. So you have to file a tax return when it's funded, and you have to start paying taxes after it's funded with a certain amount, and that amount will vary.
Okay. Let's see. So we have a lot of people asking about the handouts. The handouts are in the chat section on your screen. It should be one of the middle icons. It sort of looks like the quote bubble. If you click on that chat section, you'll see that Colleen McKay Wharton did post that link. So please feel free to copy and paste that link to access Hillary's PowerPoint from today. And we will absolutely have the recording of today's presentation posted on CLEP's website over the next couple of weeks, hopefully sooner. Let me just get to a couple of more questions if you have a few more minutes. Hillary, we have a lot of people asking about costs of guardianship. I know that could vary. Can you just share your contact information?
If you want to contact my office for the cost, you can call 609-454-5609. You can always email me, but I generally don't like to talk about money or costs in these presentations.
Perfect. Let's see. Just trying to get through to some of these other ones. There are a lot of duplicate and a lot that I think you already addressed. So let's get to one last one if you're good. How long does it take for DDD to step in when a client does not have a guardian?
Every lawyer starts out with it depends, and it's true. It depends on where the circumstances of the child, where they are at the time that their situation would be brought to DDD's attention. So if they're living in a group home, the group home will notify DDD right away. If they're living at home with you and something happens, then it would have to depend on who's around to bring it to DDD's attention. But they would step in pretty quickly once it's brought to their attention.
Wonderful. So I know that we're definitely past our time. Hillary, thank you so much for taking the extra minutes and
No problem.
a long presentation to provide this one-on-one overview on guardianship and special needs trust. So again, thank you so much. It's always a pleasure working with you. And again, for everyone who attended today's session, thank you so much. The Community Living Education Project is really focused on offering presentations such as this to really address the needs of the community. You're going to see a really brief post survey pop up on your screen as we're hanging up from our session. It's information that you provide us that allows us to plan for future sessions to better meet your needs. If there's anything that CLEP can do to help support you or your family as you're exploring community living options, feel free to reach out to me. Again, Melanie McGacken, it's 732-718-0572. Also my coworker, Natalie Trump, it's 732-673-7005. You should have our information within your confirmation email also. So feel free to reach out. And again, look for our upcoming webinars, and thank you again for joining us today. Please have a wonderful holiday, everyone, and enjoy the winter. Hillary, as always, thank you.
Thank you so much. Happy Thanksgiving. Happy holidays.
Thanks. Be well. Thank you.
Goodbye.